Well, good afternoon and welcome. I'm Merit Janow, Dean of the School of International and Public Affairs, and it's really my great pleasure to welcome you to today's program, which is the Gabriel Silver Memorial Lecture. The Gabriel Silver Memorial Lecture was established at SIPA and at Columbia in 1949 in support of public lectures at Columbia University on subjects of world peace and international relations. This is our most important annual lecture, and past Silver Lectures have included some truly remarkable individuals, including Dwight D. Eisenhower when he was president of Columbia University, Rajiv Gandhi, Pascal Lamy, Shirin Ebadi, Nobel laureate, Larry Summers, and others. And so we really are proudly carrying forward this tradition of eminent Silver Lectures by welcoming Associate Justice Stephen Breyer to Columbia University. Thank you so much for joining us. We're really honored to have this chance to discuss with Justice Breyer his magnificent new book, The Court and the World, which is really an important look at a challenging and crucial set of questions: how the court, in so many areas of law, has come to consider and interact with the laws of the rest of the world. And it's an incredible privilege for me to participate in this conversation with Columbia University President Lee Bollinger. Under his leadership, Columbia University is taking substantial and many serious steps to engage what globalization means for a great research university. He's established a committee on global thought, created our global centers around the world, created other fora to stimulate deep thinking about what a truly global university means, intellectually and with respect to students and faculty. I think he's stimulating intense considerations of how the university can more deeply engage global challenges in those areas where we are uniquely able to contribute. And of course, he's a wonderful champion of SIPA and our mission. But of course, President Bollinger is also one of America's leading constitutional and First Amendment scholars, a former law school dean, and a leading advocate for affirmative action, diversity, and accessibility in higher education. I think just this week, Harvard Law Review Forum published a commentary by President Bollinger in advance of a new ruling in an upcoming case. But today, we have an extraordinary opportunity to hear from Justice Breyer. Ladies and gentlemen, please join me in welcoming University President Lee Bollinger.
Justice Breyer, we're thrilled to have you with us this afternoon, and I'm glad to have this wonderful audience. The subject here is the world and the court, globalization, legal systems, and from my point of view, this is extremely important. It is really going to be the future of the lives of those students who are here today. Justice Breyer has taken positions on this that I think are incredibly creative and very, very greatly needed. From the standpoint of free speech, free press, some years ago it began to occur to me that as there were more and more global issues and there was a global communications technology, the internet, that made global communications possible really instantaneously for the first time in human history, there was now a need to think about free speech, free press on some kind of global scale. And would there be international norms that we could evolve over time? And how should we interpret the First Amendment and the Constitution in light of this? Well, Justice Breyer, this is his subject. And so really very fortunate to have him here today. I think all of us really look at Justice Breyer as a model justice in so many ways. Principled, pragmatic. These are words that are used often with him. An elegant writer, a very, very deep thinker. And so with all those things, please join me in welcoming Justice Breyer to our hearing.
Thank you.
So let's start with sort of, if you could describe, Justice Breyer, what is happening in the world today that looks like it's making a fundamental change that is the basis for thinking about the court and the world in new and different ways. So let's just go first to what is it that occurred to you to write about the world that caused you to write this book?
Well, while I'm thinking about that, I'd like to thank you for inviting me to Columbia. In preparation, about 3 or 4 weeks ago, I went to see Hamilton. Have you seen it? It's very, very good.
Yeah.
I asked you, Hamilton did go to Columbia, you know. But there was no law school at that time. Think of what he could have done for this country if there had only been a law school at Columbia. Right. That's true. So it's really nice for me to be here. You're interested, I hope. You know, the normal thing with a book, you write a book, sees a friend. What have you been doing? I've been writing a book. Oh, I read your book. Oh, you're the one.
Right.
You said, that's normal. But the fact is, why did I write this book? Because I wanted to put down on paper some of the things I've seen in 20 years. Go back 20 years, there were cases involving you had to know something about what goes on beyond our own shores, laws of other countries or international law, few, and now there are a lot. It's going like that, 15%, 20%, that's a lot. So all I'm doing is I'm giving you a report from the front. I mean, on what? You hear these same words, and he started out, you see, very carefully the president began to edge towards a question which he knew I couldn't answer. What is globalization? What is interdependence? What do all these words mean? Well, I say, I haven't answered them, and I haven't tried to. I said, well, we're in the position, if you've read, it's a good book. I'm not saying it's, well, I'm not even talking about my book for a change. I mean, I'm talking about a very great novel, The Charterhouse of Parma. And in The Charterhouse of Parma, the hero, Fabrice Del Dongo, is at Waterloo. And he's sitting there, and the guns, bullets are flying, the horses are running around, Napoleon's going back and forth on this white horse, and smoke and everything. And Del Dongo thinks to himself, you know, he says, something really important is going on here. I wish I knew what it was. Now, that's what I feel when I hear the words interdependence and globalization and the kind of question you were asking.
Right.
So I thought I might shed some light on that by giving a certain kind of lens with which I'm familiar to look at that question. I mean, what do I know? For 20 years, I know the court. And so I want to say, how has the court changed in this respect? What do I see on our docket? Let me tell you a few of the problems classified and sort of thought about, so you have categories of what we are seeing. And that might give those who are interested in that area an opportunity to draw their own conclusion, but give them a view on what's really a bigger picture. Because I thought this bigger picture has nothing to do with the philosophy of judges. It has to do with nature, changes in the nature of the world. Now we can go into some of those if you'd like.
Absolutely. I think it would be wonderful if you could speak to some of those examples and what it means to look to foreign law. I mean, what are the consequences of that? There are those who are deeply worried if we refer to foreign law, and if you put weight on foreign law. Could you speak to some of those issues?
No, well, I'll give you 2 or 3 examples. I'll give you the most dramatic and probably a very important one where I have no idea what the answer is. But all you have to do in your con law class is to ask your professor. This is good. I'm glad I never taught it. This is good. You say, what does the Supreme Court, what's it said about executive power, particularly the power of the president to act during a national security emergency? What did the founders think of that? I like that one. Because what Justice Jackson said, they said, he said, when you look into the actual cases, you will discover it's sort of like Joseph trying to interpret the dreams of Pharaoh. You cannot figure out what they're saying. See, you're not alone in this. Why? Because for many, many years, in many situations, not entirely, but mostly, the Supreme Court and other courts in the world followed the advice of Cicero. Cicero, 2,000 years ago, said, my Latin teacher told me this in the 10th grade, and I thought I got a great translation for it. I used to translate it. I said, when the cannons roar, the laws fall silent. Oh, but somebody told me at one time I used it. He said, the Romans didn't have cannons. So I said, well, all right, you've got the idea. You get the idea. In wartime, the courts say nothing. Go back to the Civil War. Lincoln put tens of thousands of people in jail. Seward, the Secretary of State, called in the British ambassador and he said, you see that bell on my desk? I push this once and I can have anyone I want. In New York, thrown into prison. Over here, anyone I want in Indiana. Tell me, does the Queen have such power? Now the court did get into it, but not until the war was over. And go read something about Woodrow Wilson in World War I and what happened to free speech then. And go back and read, everyone knows this case just about. In World War II, I was born in San Francisco. I remember driving with my mother to Tanforan Racetrack, which was just south. We go down a little road and she said, that's Tanforan Racetrack. That's where they held the Japanese on their way to camps in the East. 70,000 American citizens of Japanese origin, okay, taken against their will and put in camps in January of 41, February, March, April. DeWitt, the general in the 6th military district in the Presidio, he said, well, we have 785 instances of signaling to Japanese submarines offshore, and there's 6 or 7 instances of sabotage. J. Edgar Hoover, head of the FBI, said, you're wrong. There isn't any sabotage. We can deal with it. Earl Warren said, no, put them in camps. Warren said it was the worst thing he ever did. But they did put them in camps. 1944, Fred Korematsu says, I'm going to sue. This is ridiculous. I'm an American. I haven't done anything wrong. His parents were against it, said, don't rock the boat. He said, I'm rocking it. And he got Ernie Besig, the head of the ACLU in San Francisco, who used to play poker with my father. And the ACLU, by the way, wouldn't support him in the lower courts. They did eventually. But see, there's a war going on. And Korematsu thought he couldn't lose. The case gets up there by 1944. There's no risk from the Japanese invasion at that point, and he's sure he can't lose. But he lost 6-3. And at that moment, 2 lawyers in the Justice Department, Ennis and Berlin, they had gotten very suspicious of the Army's rationale. And they went to the FCC and said, what about those 783 instances of signaling? 2 weeks later, they're back, the FCC, with a study like, he says, there wasn't one. They were all buck privates. They didn't know how to work the equipment. He said, you did a great job learning all that so quickly, says Ennis or Berling, I don't know which one. And the FCC man says, no. We didn't do this now. We did it at the time. And we showed it to General DeWitt. He knew it. Okay? So they write a footnote because the lawyers say we're not signing the brief. They write a footnote. The person who wrote that footnote, who's the most famous law professor just about in this Herbert J. Wexler.
Yep.
Herbert J. Wexler wrote the footnote. Fabulous footnote. It says we disown the Army completely and nobody can understand what he's saying. You have to read it 19 times before you know. So I always thought, well, the court never read the footnote. But I read the transcript, and Charlie Horsky, well known in New Deal days, representing the Japanese American Defense League, says to the court, read the footnote and read it till you understand it. And you will see there's no justification for this. How in heaven's name did they lose? After all, Murphy wrote a dissent where he explained this perfectly well in dissent. I called Murphy's law clerk, Ressman, who wrote the Supreme Court practice. He's now 95 or 98 years old or something. And I said, what happened? Did the Justice Department sneak in and tell you all that? You know what he said? He says, I don't remember. So there we are. But I did learn this from somebody who's read the notes, that black, the people in the majority black, Douglas, Frankfurter, the liberals in Brown versus Boer, black walked into that room and he said, somebody has to run this war, Roosevelt or us, and we can't. So it's Roosevelt. That was the argument. 70,000 Americans. So by the time we get to the steel seizure case, Jackson, Truman seizes the steel mills to get steel to the Americans fighting in Korea, and the court says, no, you've gone too far. The court was saying, Roosevelt, you've gone too far. And it's much easier to say, Roosevelt, you're going too far when Roosevelt's dead, and it's Truman, because Truman's a lot less popular. So that's what they say. Now we come to Guantanamo. 4 cases. Each one of those 4 is won by the detainee. Strike down a law which says the detainees cannot get into court. You see that violates the habeas corpus provision. But the key words, it's a long windup for a very short pitch that I'm doing. But the key words in that are, the Constitution does not write a blank check to the president, not even in wartime. Sandra O'Connor writes those words. I agreed with them. And now, as soon as you hear those words, as good law students, I'm sure, or professors, and what in associate, the first thing that occurs to you is fine. The Constitution does not write a blank check, fine. What kind of check does it write? And we're criticized a lot for that opinion. On the one hand, people say, what are you interfering with the president? You think you know anything about security or terrorism or any of these other bad things that could happen to us? To which I can, you want to go back to Korematsu? Is that what you want? You want a constitution that allows that to happen? Well, okay, then on the other side, why weren't you more specific? Why didn't you say something about hearsay? And I say, you want me to be truthful? Because I don't know what to say. That's why. Because there is really a problem. And so now, that's the whole wind-up, and the pitch is, now what do we do? And why do I ask you that? Because you're the ones that have to figure it out. You say? I can say a few things that are almost the level of being trite. But I can say there are ways of finding out. The lawyers help. The lawyers say when there's an infringement of civil liberty, even during wartime, why? Why do you really need it? And still questions will arise there. The government will have an answer. Is the answer heard in camera, or is it heard in open court? Is it heard with the other lawyer present, or is it ex parte? I mean, there are a lot of questions in here. And the lawyers can say, why not? Why not do it this less restrictive way? Okay, okay, fine. Which less restrictive way? How are you going to find out? And I can say things such as, well, I at least what we can do is find out more than we know about security problems and look and see what other countries do. Maybe we'll learn something. We're not the only ones in the world that are facing these kinds of threats, nor are we the only ones who have traditions of civil liberties and democracy. Let's see what they do. Let's work on it together. But working out those kinds of things is going to be complicated, difficult. What I'm saying is trite. But I brought you this long distance because I want you to see where I think we are. And I think we can't go back to Korematsu. That, in my opinion, would be simply terrible. But if we're going forward, we have to, I tell you, the government will tell us about the security problem. We'll get a brief from the Solicitor General. You think it's going to say we were wrong to impose this measure? No, it's not going to say that. It's going to say how right we were. And how are we to test that? Are we to take just his word for it? Or what? And how is this going to work? How does it work in Israel? They have systems in Israel that are interesting. England, Britain, we're going to do an exchange with, we did an exchange with the British judges. They have a rather interesting system there. And there are other ones in France. And how this works, I'm not saying you ought to know it out of some intellectual curiosity. I'm saying you ought to know it because the problems are in all likelihood going to be right in front of the courts, and whether you're there as a judge or there as a lawyer or there as an interested person, you have to have an idea here about how not to go back to Korematsu and how to make some progress here without blowing up the country and without destroying civil liberties. All right, so it's easy to say it at that level, isn't it? And then I say, well, it's your problem. That's because we'll work it out over time.
So let me
So let me ask, I mean, I'm trying to think about how to take what you've said and to sort of weave it into your theme about this new generation is going to face a world that is different from the generation we have faced, and they're going to have to face learning things, knowing things about the world that, you know, we from a legal standpoint could say that's somebody else's problem. So your thesis is that historically, back to Cicero, through Stendhal and Flaubert, through the Second World War, First and Second World Wars, the attitude of law in general was, when it comes to kind of foreign affairs, whether they're wars or national security issues or whatever, we in the legal system will defer much more to the political judgments, the branches of government that are responsible for conducting these things. We will stand back, and we will. But your point is that has led to some of the greatest injustices that the country has committed. But secondly, the world has changed in ways that make it no longer possible or advisable for us to step back and just defer, right? And those are going to come more and more, and what does a university do? What does a law school do? What does a school of public policy do? What do we do in law to advance the ability to be able to address that changing world? What do you wish you knew now that would help you address this rising set of issues and problems that you don't have?
Can I give you one more example and you'll see the answer? What?
Yes, of course. Of course.
All right, you see, because the most obvious example of this change is in the area of commerce.
Yeah.
Right.
And that's easy. So the change is so obvious. Like what? I mean, what are I could get 4 or 5 of those. A vitamin distributor in Ecuador is suing a manufacturer in Holland because he says they're part of a price-fixing ring, right? And they were. And there's an American member, and he's suing in New York. Why is he suing in New York? Well, one possibility is, you see, his vitamin price is very high, he can't afford to buy them, and he's too weak to get to Holland. That's possible. Could have happened. Another reason is treble damages. All right? So he wants to sue in New York, and there's a statute. And the statute, which is an American statute, says whether he can or not, except it doesn't quite say it all that clearly. So we have to interpret it. Now, interpreting it, you'd have to go back and look at it, but I would say we could not have done it. We couldn't have done it. I couldn't have done it had the EU not filed a brief that explains very clearly. Japan filed a brief, I think Germany, I think several different countries and their lawyers, and they explain how the EU anti-cartel mechanism works. And you can see whether there's interference there or not. The same thing's true in the securities cases. The securities cases, an Australian buys a security in the exchange in Australia, in an Australian company. Which Australian company has bought an American company? Which American company made some money through some fraud in Florida? All right? Can they sue under 10b-5? You, again, would not have, Henry Friendly would have decided it differently. We decided no. Yeah. And one of the reasons no is we had briefs from all over the world, including securities authorities, saying, stay out of this. Stay out of it. You get into this, and you will wreck our system of dealing with the same fraud problem. And I can give you other examples, too, but those will suffice, because what I want to show you is this word comedy, which used to just be some very esoteric word usually in a, I mean, I took international law from Roger Fisher, and it was viewed as a somewhat easy course, and we talked about Sabatino the whole time. But that isn't what it's like now. Comedy now, I think, and I can give you several cases on this, is not simply, you stay out of it, it's theirs. It's how do you interpret an American statute, given what other people are doing, so you can harmonize and further the similar advance of similar areas of law in many different countries, which in the antitrust case is to stop price fixing, which in the securities case is to stop fraud. And that requires knowing something about it. And I can give you examples in copyright, I can give you examples all over the place. So you say, what do the law schools do about it? I say the law schools do what they're really good at. The first thing that they're good at is the law professors traditionally were, and I believe still are, very good at reading different cases, knowing what those cases stand for against a background of knowledge of the area, which the judges don't have, and which not that many lawyers have. Then they write about it. And they say, but he didn't know over here there's this, and this is going to do that over there. And before you know it, you have a treatise or an article which rationalizes the area, which is read by the lawyers. The lawyers then, when it's useful to their case, present it to the judges, and the judges see how they might improve on the work they've done, modify what they said, and back we're into the circle again. So there are three parts of our profession: the judicial part, the lawyer part, and the academy. I must be speaking too loud. But that they work best when they work together. Other thing that they taught us in law school, we hope, is how to look something up. You can't teach the law of the world. Nobody knows the law of the world. But you could sometimes, in a contract case, bring in something by way of comparison so that the law of the world doesn't just end up in a course called comparative law and international law, but bits and pieces of it, even in an antitrust course, come in for a week. A week isn't that long. You can teach a lot in a week. And so there are ways of bringing it into the curriculum because it will be part of the lawyer's life. Above all, to teach the lawyer how to look things up and include it in the work called rationalizing the law. I don't see that that's so tough because that's what law professors do every day of the week. It's their job.
But let me ask you how, these economic cases are I love these economic cases, and I really enjoyed that chapter in your book very much. And I was left saying, well, let's take comity. This has been an evolving concept. But for you to even get to comity, the U.S. has to have a stake in reaching the conduct. If it's just a foreign against a foreign, it's not a U.S. matter. So there has to be a U.S. stake before you even get to comity. And if we have a legitimate stake, then how do you weigh the foreign sovereign claim or the foreign claim against the U.S. interest? Could you share your thinking about how you think we should be weighing these factors, even in a world where there are bilateral agreements and foreign leniency programs and a very complex web of relationships, but the U.S. does have a stake in. We
always will have a stake. I mean, if the case is in front of us, you're right, there's some U.S. connection. In the case of the antitrust, that case, there were American consumers who did pay higher prices because of the international vitamin cartel. In the case of the securities matter, there were people who were affected when the Australian company bought the company that had a connection in Florida. So there always is some kind of an interest somewhere that gets you into the matter. Once you're in it, that's where the briefs come in. I thought what was quite good is the restatement, I think, of international law or whatever. It uses the word reasonable quite a lot. I think that's awfully good. They might think they're not saying anything when they say reasonable. It isn't that helpful. Well, it's helpful to me because what it does in the court, it allows you to work with the facts of the case and the briefs telling you how they're trying to run. See, they're trying to run their fraud division over in Europe. And they're saying, now, if you decide this way, our whistleblowing program is going to go out the window. See, nobody will tell us anything about what's going on in the company because they'll be afraid of the prosecution over there. So you've got to draw a line somewhere.
This is really, it seems to me, very important. So let me state it and see whether this is what you're saying. So it's one thing, I always hate it when people put things this way because it sounds like you're drawing a distinction. In fact, you haven't given a reason. It's one thing to say, you know, in courts, it'd just be good to find out what's happening in other places in the world because maybe they have some good ideas out there. Probably not, because we have all the good ideas most of the time, you know, that kind of thing. So let's do comparative law in the sense of look for other, maybe there are some other ideas. That's one thing. Another thing, which I think I hear you saying, is a justice or a judge should have an interest, a part of his or her mind, that is trying through the decision to make a better world, a better legal world, not just the US world, not just, you know, what's the US interest at stake, and my job is to maximize that at all expense to everything. You're actually proposing that a judge or justice try to build through the cases a world that is better. Other interests are taken into account. Building an international legal system through this kind of ad hoc, somewhat ad hoc way, but still nevertheless the only way we have because we don't have an international Supreme Court. That's a big step, right or wrong?
90% right, except I think that the 10% is that the judge doesn't have to sit out there and start thinking how I'd like a better world. The judge just has to do his job.
Yeah.
I mean, for example, you have Kirtsang, who is the Thai student who was at Cornell, who discovers that the same textbooks that he's paying for there are about half the price or something in Bangkok in English. So he says to his parents, send me a few. Well, they sent more than a few. He began to sell them. The publisher got annoyed, brought a lawsuit, and the question was, does he have the right to do that or not? And the answer lies in an American statute, and the American statute is sort of like Wexler's footnote. You can't understand what it's saying. All right. So I go to my office, and there is a stack of briefs like this, and from all over the world, from Asian publishers, from governments, from all over the place, all kinds of industries. I couldn't figure out why are there so many briefs. See, that's a question I have. You don't necessarily have, but I walk in my office. I think, why are there? All right. But in any case, there were a lot of briefs, and finally, towards the bottom, I'd taken in the point why there are so many, because copyright today is not simply a question of books or books and music and film, everything. It's automobiles, the software is copyrighted. You go into any store you want and look at those labels, they come from all over the world, they're all copyrighted, okay. And so in one of those briefs it says your answer to this is going to affect $2.3 trillion worth of commerce, okay. That's a lot of money, even today. And there we are. I didn't do that, but to get the right answer to that question, which will involve $2.3 trillion, it turns out I have to know as a judge, not my free choice to make a better world. I have to know about the Berne Convention. I have to know about how other countries' publishing systems might work or might not. That's part of my job. And if you want a question that I think is likely to come up, which I think is amazingly important, but I think it does, it isn't there yet. We've dodged it a few times. But look, Sabino Cassese, who's a very good law professor in Italy, set his research students out to answer this question. Think of the United Nations. Think of the World Trade Organization. What they have in common is they are created by treaty or some kind of international agreement of some sort. They have bureaucracies. Those bureaucracies make rules, and those rules affect more than citizens of more than one country, citizens or businesses. He says, how many such organizations are there in the world? I mean, that can make rules that in practice, I'm saying whether it's law, but in practice bind people. How many here think, you study, how many here think they're more than 500? Nobody thinks they're more than 500? There are more than 500. More than 1,000? More than 1,500? More than 2,000? Well, there are more than 2,000. All right? And we belong to about 1,000, 800, 900. I mean, you've heard of some of them. You heard of the UN, you heard of the WTO. You might have heard of the Bluefin Whale Commission. What about the International Olive Oil Council? Yeah, it's a good organization. And they're all over the place. And one of them, it's surprising this doesn't pop right into your head because it affects your life every single day. And it isn't even a treaty-created organization, I don't think. It's a corporation. What affects you most? I mean, it's affected you 7 times in the last hour, probably, or last day. You're close, Apple. It's not Apple. Apple's a company, but Apple's regulated by who? Do you know? Not everybody knows the answer. Icon, have you heard of Icon? Icon is in Los Angeles. It's a company. It controls domain names. Who regulates Icon? It does affect you. And by the way, when they met, Bern, what about Bern? In Bern, they meet who? The banks and the bank regulators. So the SEC sends some staff over to Bern to figure out what to do about banking. And they do a lot. And then they decide. And then they come back and the SEC has notice and comment rulemaking. I see. You mean it's being decided now in the note, ha, ha, ha. It was decided then in Bern. And people in the room then? Nobody. Except for the regulators and the banks. All right? Now, is that going to last? I suspect maybe not. But the question, the big question there is, and these are just small examples, with that many organizations, why is there a Bluefin Whale Commission? Because it's obvious, they're in danger, right? There are problems. There are problems of environment. There are problems of security. There are problems of health. There are problems of commerce. There are problems and problems and problems, and those problems in a world where you will see vast movements of people from the countryside into cities, where you will see energy needed all over the world where it now isn't, and coming from across borders. In a world, in other words, which is our world, you will see the need for rules. And the question is, how do you make them? And I say, why is this such a big question for us? Well, quite simply, Congress will delegate to all those people the power to make rules to affect us. If we don't, how do we work with the other countries? How do we solve the problems if they don't delegate the power? But wait, if they do delegate the power, I mean, when and under what circumstances do we run into this question? Article 1 of the Constitution says that the legislative power of the United States is in a Congress, not in the Bluefin Whale Commission. Does this begin to sound familiar, this question? It's the same question in kind that the Supreme Court faced in the 30s and in the 40s when they decided Crowell v. Benson. What is an administrative agency? What is it? How can it exist? It's not in the Constitution, but they figured out a way. But they haven't yet figured out a way for the Bluefin Whale Commission. Nor, in fact, have we yet had the question clearly posed, though we have had slices of it posed, and Bond, for example, and as I said, we dodged it. We dodged questions like this. We're just getting into them. And what will the answer be? And if you think, I'm making this up, go read the German Constitutional Court, or the Italian, or the Austrian, having had to decide to what extent does the Constitution of Germany give the German government the power to sign the EU treaties and thereby delegate legislative power to the EU, power which the Constitution says, at least to some degree, rests in the hands of the lander, the states. And each one of those courts has said it does not give them total authority. Each one has said there has to be reservations. And each one has never found an actual reservation that had bite. But nonetheless, do you see the kinds of problems? Well, there they are. Are they because of some radical international justices? No. Right. And I'm sort of carried away here, but to your question, the person who doesn't want us to refer to foreign cases, Congressman Goodlatte, I used to have a debate with him. I like him. He's a nice guy, very bright. And he says, I said, well, he launches into a thing we shouldn't refer to foreign cases. I said, well, I guess that's referring to me. He says, yes. So I said, okay. I said, let me tell you why. They have problems like ours. There are courts like us. They have documents like us. Why don't I read it? I might learn something. He says, read it, just don't refer to it. So I said, well, it's more than that. I said, there are a lot of new courts in new countries, and they're giving power to these courts to try to have some kind of stopgap to protect human liberty. And they refer to our cases. If we refer to theirs, they might be able to use it. Give them prestige or something. Go to the legislature and say, don't cut our pay. He says, fine, write them a letter. Don't refer to it. So I work out what's bothering him. What's bothering him, in fact, is not these sort of arguments. Everybody has loads of arguments. What's bothering him is that our basic American values, and that has significance. He's afraid we're going to lose them. He's afraid that in all the judges copying this sort of professional guild, and they're all sort of slightly left-wing, and they're all sort of da-da-da, and you're going to end our unique and special need to protect democracy and human rights and divide power and not have too much power and be sensible, whatever. You say that's the American value. So I write this book in large part aimed right at him, because I want to say, I agree with you. I agree with you. But I want you to see that the best way, in my opinion, given the list, the best way to protect our American values is to know what's going on beyond our shores, not to short-circuit that process. Now you have the whole book.
So I think it's very, very powerful, and of course, knowing your administrative law background and that's a kind of insight into globalization, the evolution of global rulemaking and global kinds of regulations that I think is really quite fascinating. And of course, what we're talking about today and the tension you just raised, I would say is at the base of a lot of the political craziness we are facing right now in this country and other countries are facing. You can't nod or agree with that or anything, but I will say it. I'm free to do that. And but the sense of dislocation that many people feel or have affected or believe might happen is kind of at the root of national debate. So legal systems are this. Shall we open it up? And Jillian Lester is going to start.
Okay, Dean of the Law School.
I'm Jillian Lester. I'm the Dean of the Law School. It's really a great pleasure to have you here. This is a mixed audience of students and faculty from the School of International and Public Affairs as well as from the School of Law. And so, as the Law Dean, I want to thank you on behalf of all of us, but also in particular on behalf of those of us from the law school and the legal community here at Columbia. We're so pleased and proud to have you.
Well, thank you very much. Thank you.
So I've got a question that's got a methodological element and a conceptual or philosophical element. The methodological is this, that there are different ways to incorporate ideas from foreign laws or international laws. One is to simply say it's okay to cite them. That doesn't become a site that has to be that's sullied or that can't be taken seriously. An alternative way is to say you must consider them. So the first constitution I studied was in Canada before I immigrated to the United States 30 years ago. And the Canadian Constitution has a section called Section 1 that explicitly requires, when considering the scope of a right or freedom, a step in which you have to ask, is this interpretation justified in a free and democratic society? It's an explicit step. I'm sure you're familiar with the Section 1 of the Canadian Constitution just from your own path. That's a much more affirmative requirement on the judiciary when interpreting the Constitution, that they have to consider that clause has been interpreted as requiring consideration of other practices in other free and democratic societies. So that's the methodological question. I mean, would you go so far as to do that, or are you just really trying to say, let's just get to the place where it's okay to cite a foreign case? A. But B, the conceptual question is this. Well, especially if you use the approach that requires that you consider it, this is the death of originalism. I mean, arguably, the path of saying you must, certainly, but possibly even the path of saying you may consider and weigh practices from foreign, that come out of foreign constitutions or practices outside the United States Constitution really pushes the decision maker into a realm of saying, my sole source isn't the original the original framer's intention. I mean, it really is a rebuke, arguably, of originalism. And so I'm interested in your comments on both.
It's very interesting what you say, and I'm delighted to be here for both groups in the law school. Reactions, just a set of reactions, no problem with may. I can refer to what I want, What are they going to do? I don't think they'll impeach me if I cite Henry Friendly. And I refer to law review articles, I've heard, has that not been heard of? And so I can refer to what I want. That's not a problem. And where relevant, fine, use it. It doesn't hurt. It doesn't prove it, not binding. So what? Must where you must. I mean, you're not going to get a sensible decision, I don't think, in the Empagran case, nor will you get a sensible decision with our friend, the copyright, Kirtzang. Without it, and of course you're going to. Nino will agree with me, you still agree. Why are there 3 cases in 2 years involving the interpretation of the anti-abduction of children statute out of The Hague? Why? When, after all, who knows nothing about family law? I mean, the family judges know something about it, and Judge Eddie Ginsburg up in Cambridge used to tell people in his court, you decide yourselves, make an agreement, because if I have to do it, I'll do it badly. That's his profession. That's a really tough job. And state judges know something about it. You know who knows nothing about it? Federal judges. And even less, the Supreme Court of the United States. So why are we doing this? Because it's in a treaty. And all we have to do is referee between those groups who are strongly anti-abduction and those groups, women's groups typically, who are anti-spousal abuse and feel that this is connected. Okay? Well, we're wonderful at that. I put in sarcastic quotes. I mean, we don't know. So why are we doing it? As I say, because today marriage is more and more a matter for people who live in different countries. That's been heard of. And it's getting more, not less. I didn't do that. So of course we have to refer to what other countries do when we interpret a treaty. And that means the people who follow these things in that area have to be alert to the need possibly to change the treaty. Is that? And in the commerce cases I talked about, it's something else. And in the case like Mrs. Phil Ortega and the human rights law, it's something yet again. How you get a system that will work in the absence of a Supreme Court in harmony and not be at each other's throats. So everybody indicts Henry Kissinger, which I don't know what. But in any case, do you see the problem? Different problems in different areas. And above all, if you want me to choose one that I think is absolute importance, the figure I heard the other day, not far from here, but an architect who was speaking at the UN. I don't know if he's right. I imagine he is. He knows his facts, usually. He said today, there are 3 billion people living in cities. 3 billion. Of those 3 billion, 1 billion do not have enough money to buy living space. Yet under $10,000 of the family, they can't do it. In 2050, no matter what we do, in 2050, there are going to be 5 billion people living in cities. And of those, 2 billion will not have the money to buy living space. Now, all you have to do is think, I won't do that for you, you're better at me. Think of the implications of that. And think that you can't stop it. And think of what the implications are going to be about for poverty, for security, for wars, for movement, for climate, for all kinds of things. And then you will see a world that is developing, and where I jump to with that is there has to be, if this is going to be livable and under control, systems of law that are united in such ways that they facilitate, rather than stand as individual obstacles, to countries and people working together through rules, regulations, all kinds of different systems to help deal with the problems that it's going to create. Why? Of course we believe that as lawyers. We all believe that. But it's more than that, because if you do not have a system called the rule of law, there's only one other way to deal with problems of the human race, and all you have to do is turn on the television set and look at a few of the things that are going on, and you will see what that means. So there isn't much choice. And so that's where I see this as being a must.
Could I invite Bentley McLeod?
Thank you very much for, does that work? Okay. Well, thanks very much for coming to Columbia. We really appreciate that. In particular, it got me out of the class because I brought my law and economics class here to listen to you. So, and you're doing a much better job than I've ever done in class. One thing I want to do is get back to your sort of statement about American values. And since I'm an economist, not a lawyer, I don't have the subtlety or the depth of knowledge of the law, but try to view things in kind of simplistic kind of way. And my first book I read by you, in fact, was your book on regulations reform.
Oh, that's very nice.
It's actually it's a great book.
14 cents on Amazon you can get.
It's the best deal you can get on Amazon today. We used this book when I was in Canada teaching graduate industrial organization, and I must say it was extremely clear, and I thought, my gosh, these lawyers in the US are smart. But what I want to ask you about is sort of, in some sense, one of the things you talk about in your book right now is about the Alien Tort Statute. And in particular, as an economist, we try to sort of think, well, what are sort of, we have specific goals, like make the world a better place, and then we try to think, what are sort of best ways of doing social control? And in a sense, in simplistic ways, we have two forms of social control. One I would call sort of the regulatory approach, and I think Glazer and Schleifer, document the rise of regulatory state in the U.S., which is basically sort of an ex-ante type of control system. We can contrast that with tort law, which is an ex post kind of control, where you basically, which I would say sort of is from the UK, but I would say sort of a part of American values. One way to think about that is sort of a simple point, but one that's easy to see, is in the case of gun control. So for example, in Canada, we tend to say that people shouldn't have guns. In the US, as an American value, we feel people should have guns, but then they'll face the consequence of using the gun. So in one case, you have an ex-ante control over behavior, the other one is ex post. And sort of occurred to me as I was reading through your book, is in a sense, when you come to the Alien Tort Law, it's sort of something that's occurring in reverse. So the first part, you talk about how foreign laws, which are regulatory, they're controlling things ex ante, are being brought in. And I can sort of see that for some Americans, they would view this as sort of the rise of the regulatory state and have some resistance to that. But then the reverse side, the Alien Tort Statute is an example of foreigners bringing cases in the US as a tort. And tort law, as an economist, has a lot of desirable features. It allows very rapid response to particular wrongs, and in particular, when you have a venue in the U.S., which is a financial center, allows those wrongs to be dealt with quickly. On the reverse side, the regulatory state, one of the reasons we find problems with, it's very slow. Getting climate treaties forward is extremely hard. So in some sense, I would like you to comment a little bit on these two types of controls, and to what extent we can see the court, in some sense, pushing American values out via tort law, which is totally, when I teach law and economics to, especially my Europeans, they simply find sort of amazing that the U.S. system is sort of this incredible view of the law, which is sort of rational and tries to make the world a better place. They just never viewed it that way. I've had Swiss lawyers say this to me in my class. And so I'm sort of wondering to what extent I could view you as pushing American values out via tort law, which is the regulatory approach.
I'm hesitant to say that either tort law or regulation is a basic American value. I mean, when I think of basic American values, I tend to think it's corny, but I tend to think of Abraham Lincoln and James Madison and what's written into the first 10 amendments. I tend to think of the tort law or regulatory system as different objectives, as you say, and you sort these things out and try to convince people which is the better system in this particular method. I just read a critique of, it is true. I mean, I was quite surprised and rather interested. Well, three things. One, I discovered in my job that the fact of whether I advocated deregulation or less regulation or this, it doesn't have much impact. I mean, I can, as the case I brought up in one of my books, which was, I thought, was just an example of awful waste, where they tried to clear some plot of land to the point where if you had dirt-eating children eating dirt for, 10 years, and they shoveled in all this dirt, they still wouldn't get sick, and they had to spend $90 million clearing it up and there weren't any dirt-eating children. Then I had the case it actually came out of. I had to decide for the government, because the government was right on the law. They did have the power to do that, you see? And that's how it appears more often legally. And I have found in some cases we have surprisingly, given where we started 40 years ago, that the EPA is using, much more than I ever would have thought they did, devices to give people incentives to move them in the right direction. And maybe because they had Cass Sunstein running OIRA. So I'm fine. And I just read a book about the European efforts to control energy, and it looks as if, according to the author of this book, that the effort to stop nuclear power, which has been successful in Germany, has meant greater reliance on coal, because you have to have coal stations in at the time the wind dies down and the windmills don't turn, and those coal stations are going to actually produce more pollution every year, and the pollution thing, the CO2 thing, is going to go like that, which it wouldn't do if they used a fossil fuel, which would be gas. So all you've done in that question, which is very interesting for me, is you've got me back to that world, which is an absolutely fascinating world. And I am hesitant to say that one or the other system, whether it's regulatory, tort, or whatever it is, I think those are means. And my hope is that whether it's Europe or the United States, the most efficient means of achieving an objective, i.e. the least cost way of, say, dealing with pollution, will eventually win out. And it might be, the one or this or the other thing. And we don't have too much to do with that. The basic values we're dealing with, I said, my little personal, my wife is paying each of our grandchildren, $20 if they can learn the Gettysburg Address. So they go around saying 4 score, there's 2 or 6 and 1 is 9. One of the 6-year-olds doing pretty well. She goes around saying 4 score and 7 years ago, our fathers brought forth upon this continent a new nation, conceived in liberty and dedicated to the proposition that all men are created equal. Now, we are engaged in a great war to see if this nation or any nation so conceived and so dedicated can long endure. Those are the words I wanted to see whether any nation so conceived and so dedicated can long endure. Because that was the question the founders put. Who else was a democracy? Who else believed in human rights? And they didn't completely, by any means. I mean, we understand that. But they were in the right direction. That's why you should see Hamilton. And yeah, fabulous, fabulous. They're in the right direction. And there they are, alone. Can that experiment long endure? That's what Lincoln said. That's why he says, I would have fought the Civil War regardless of slavery. I wanted to prove to the world a nation so conceived, not perfect, that's true, but moving there, maybe. And it's at that level that I think that, well, our experiment has not been perfect, it sure hasn't, but nonetheless, and that, I think, is the challenge in the biggest possible terms that is being posed when you look at this world which has nothing to do with ideology or the need to get together to help make it a little bit better here, there, and the other places, which has nothing to do with ideology. But that's where we as lawyers have a role to play. And it's at that level that I think, yes, you see, Congressman Goodlatte? We do have something to offer. We do have something to offer. It's called some experience with the rule of law, some good, some bad. And we can offer it, and we can learn from others who are trying to do somewhat similar things. So at least we don't go down the totally wrong drain, you see. You get the idea? Yes.
Great. I think we take a few.
Couple more?
Couple more
Two more.
questions. All right.
Could I invite Ed Knight if there's a...
Yes, Justice, thank you for your public service. You're an inspiration to the profession. I have a relatively fanciful question, but if you'll indulge me. If you could have your way and one of our founders could be brought back tonight to have dinner with you, which one would you choose and what would you discuss with?
Hamilton! Columbia, how has it changed? No, I mean, you can't see that. You can't see it without thinking, oh my gosh. I mean, this really was something. He really was. And I did read Jernow's book. And I'd stick to my answer even if I hadn't seen the musical. But my gosh, I mean, he was certainly a brilliant, brilliant man, and his heart was in the right place. I mean, most of the time, and he developed practical, developed these institutions. How did you do it? And there we are.
But they look to international authorities and their work.
Yeah. He did. He went over to, I gather, he went over to England and stole all the business plans from the cotton mills and brought them back over here. And that was a useful exchange of information.
But isn't that relevant to your thesis?
The only impression as a lay person in this area that I've gotten from, I do read some of the history books. I read Gordon Wood. I read Ellis. I've read quite a few of the biographies. I read this recent one, The Quartet. Have you seen that? And the one impression I think, maybe it's unfair, but I think I come away with it, is the one thing you could see about the founders, what they thought in terms of any of these really details of how things would evolve, is they didn't know. And they all thought different things. And many of them thought very different things. And so they wrote this document, and the one thing they wanted that document to do was to endure, and they wanted the certain basic values to endure, but as soon as you get more specific than that, 5 more directions. That's my impression.
Agnes?
Good evening, Justice Breyer. It's a great pleasure to listen to you. I have to tell you, when I found your book and read your book last year, you really made my year. Okay. As somebody who had been working and consider myself as a global person, you provided a lot of arguments and reasoning that I could use, and I've been advocating for people to read your book. I'm running a new initiative, well, not so new now, that President Bollinger established, which is looking at the establishment of global norms. How do they come about? And we're particularly interested with the role of the judicial sector, judges like you. That's why that book was so important. Because I don't want you to think that the United States is so behind in terms of looking at the international perspective. We did a little survey of the world, and there are only 2 continents at the moment that whose judicial sector is slightly interested in the way other judicial sectors are looking at issues related to information technology and expression. It's Latin America and it's Africa and a little bit in Europe. But if you look at the world, there is a vast majority of the world that is, whose judicial sector is very inward-looking. There is absolutely no international perspective, even in considering issues such as information technology and expression that are by their very nature global. So my question to you is, maybe to follow up a bit on what Lee was saying, is really more a practical one, is how. How do we instill in the new generations of judges in the judicial sectors, in the courts, the tools, the desire, and the skills to become a global legal thinker and a global legal actor?
You'll have the students. There's no more powerful weapon. You will train the students. They'll be the ones, they're going to go to work for law firms, a lot of them. And a lot of those law firms will indeed have to know exactly, given whom they're advising, how things work in different countries. And you will have taught them how to find out. And you will have taught them, for example, there are cases, a great case in the D.C. Circuit, which I put in, is a case involving whether, I think it was whether an environmental impact statement is required by law, and the law that was at issue was a law consisting of an agreement of a committee of one of these international organizations about CO2. Did that count as a law or didn't it? It wasn't a law passed by Congress. That's the kind of case that is right here. And you can find quite a few of those cases. So you say to your
that
class,
they are push factor.
yeah, you say to the class, well, how are you going to answer this? You know, hey, somebody has to have an answer. There are two sides, all right? But what's the answer?
I'm not sure the academic sector, particularly the law school, have actually gotten to that stage where they create the new legal thinker that are internationally minded.
Oh, yeah, they will. I believe they will, because the teachers will have to stay one step ahead of the students. And so if they have to stay a step ahead of the students, they have to find out the answers to these things, and they'll find it so interesting, they'll begin to write books about them. And indeed, because they begin to write books that include American law, it won't be on the shelf that says just, oh, international law and other esoterica. It will be with everybody else. You see, because there's so many problems. It seems to me that law professors love problems. That's why they're in this area. And they'll find these problems, and they will have international impacts. And so they think of the Uniform Law Commission. Before the Uniform Law Commission, people tended to think there was a commercial law of Delaware, and there's a commercial law of Iowa, and the lawyers from Idaho began to think of the commercial law of Idaho, and then gradually the commissioners, who were from many different states, went around and began to think of what would be the better law in different places. Think of Lance's thing, the American Law Institute. The American Law Institute worked out that there was to be, and they're in the international area now too. I think it is a question of, for the economist, Say's law. All right, yes. And Dick Stewart is doing it. We have so you will teach the students how to find out what they need to know if they're going to practice at Linklaters. And you will, in fact, stay 3 steps ahead of them. And not all law professors, and not all economics professors, and not all political professors will be interested in this, but you don't need all. You just need a few, and they will be. I mean, so I'm not pessimistic about that. I don't, and I mean, indeed, when the judges find out that you're reading their opinions, they'll be delighted. Normally, an opinion, I say, they should go around out and never forget that.
Justice Breyer.
So I'm optimistic.
So let me say on behalf of all of us, we really appreciate and enjoyed this time with you. Merritt, do you want to say anything?
No, I think it's been a marvelous discussion. I wish we had more time, but we'll find another time, I hope.
Thanks so much.
Thank you. No, it was great. Thank you so much. I appreciate it.